Everyone, this is TheRealLauraB here on YouTube and from Twitter, and today I'm going to be continuing my series of the pre-trial battlefield. This is the one I think you'll be most interested in. This is when Amber Heard subpoenaed Twitter to try and get to us. So this is slightly long, but a lot of good information, so let's get started.
Hi, I'm Laura, also known as TheRealLauraB from Twitter, and now here on YouTube. I'm a researcher, new wave internet media, and commentator. I'm not a lawyer, nor offering any legal advice. Join me on a journey to review the world of celebrity lawsuits and current events. Let's get started.
Now, as you recall, I'm going through the litigation with Depp v. Heard. Amber was complaining about the smear campaign against her on social media, specifically Twitter. And what really kicked it off was when she countersued Johnny. And so that's what we'll be starting. And I have it in date order, and it's going to be interesting to see how this played out. And ultimately, I don't think she won out with Twitter, but we will see. Let's get started. So this is her counterclaim that she filed, where she first introduced what she was trying to get into her claim against Johnny about violating the Virginia Computer Crimes Act. Ms. Heard repeats above, that's fine, but we're going deeper into her counterclaim, just specific to this subject. The Virginia Computers Crime Act, Virginia Code, prescribes harassment by computer, which occurs when any person with the intent to coerce, intimidate, or harass uses a computer to communicate obscene, vulgar, profane, lewd, lascivious, or indecent language, or makes any suggestion or proposal of an obscene nature, or threatens any illegal or immoral act. The Virginia Code provides a private civil right of action for violations of this statute. Here we go. Through the conduct described above, Mr. Depp, either directly or through his agents, including Waldman acting on his behalf in Virginia, has launched a nationwide campaign, including from or through Virginia, using this Virginia litigation to harass, abuse, and discredit Ms. Heard and to cause her harm to her economically. Mr. Depp individually and through his agents is attempting and threatening to defame Ms. Heard and interfere with her reputation, career, and livelihood, and cause financial damages. And he and his agents are doing so through this online smear campaign that he has organized and orchestrated. Thus, he has explicitly threatened an illegal act against Ms. Heard. An intentional and necessary result of this action is the transmission of this information electronically in Virginia. The comments attributed to those acting on the behalf of and the direction of Mr. Depp and or his agents are also in many cases vulgar, profane, lewd, and or make suggestions or proposals of an obscene nature and or threaten Ms. Heard explicitly. As a result of Mr. Depp's conduct, Ms. Heard has suffered pecuniary and non-pecuniary damages in the amount to be proven at trial. Mr. Depp's actions are willful, malicious, and wanton, and demonstrate a conscious disregard for the rights of Ms. Heard. So this is her prayer for relief from the bottom of her counterclaim. So this is what she's out. She's really mad at us. And this is where Boozy came in and said he had all these inauthentic accounts. And it turns out there was just 13 that they found back then. So this is her counterclaim. So then we have, let me get to the top of this. This is a subpoena. This is a subpoena that she issued for Twitter based on that counterclaim. And again, I'm doing these in date order. So what is she looking for? Well, first of all, she wants them to provide everything that's attached. Now, let's keep in mind, Twitter is in San Francisco. I'm sorry. What address did they use? Twitter is in San Francisco, which means even though this subpoena was issued in Fairfax, the jurisdiction will be in California, and that's where she'll have to battle it because they're not going to help. Bear with me. I'm sorry. I'm scrolling to drive you crazy, but let's just get to what they're looking for. All posts made by Adam Waldman to Twitter account at Adam_Waldman from the period of May 21st, 2016 through present. So she's going all the way back. All messages sent to or received by Twitter account Adam Waldman from the period May 21, 2016. So apparently at this point, she's only blaming Adam as far as his agents, Johnny Depp's agents. And I think that's pretty much it. Then we get a repeat. And I'm only showing this. This is 21 pages. And I just want you to remember this. This is repeat, because I'm going to get into something later, which causes me issues in California. But this is 21 pages. This is the only screen we're interested in. It's duplicated. So let's moving forward. So then they have a status report in California where Amber Heard is demanding that Twitter complies with the subpoena, and Twitter's not having any of it, basically. So this is a status report because now it's being handled in California. Ignore this part of the Mandel company. What happened was when subpoenas were being issued early on, they were all subscribed to this or assigned to this same judge, and it just kept piling on. That just happened to be the first one. She did get him to testify. But here's the status report. Subpoena dulce tectum for document production to Twitter was issued on September 14, 2020, consisting of 9 requests as follows. So it seems that the original subpoena that was filed in Fairfax that we see publicly was updated and changed. The IP address from which this account, the account was registered. So we don't know which the account is. To the extent not included above, any and all IP addresses from which the account logged in. To the extent not included above, any and all IP address from which the account tweeted messages. If the account was ever suspended, the reason given for each suspension, which of Twitter's TOS, terms of service, were violated. A list of any and all source information for tweeted messages from this account, Twitter for Android, Twitter for iPhone. A count of the number of messages tweeted from this account that were removed due to TOS violations. For each message that was deleted for a TOS violation, the reason given for the deletion, i.e. terms of service, were violated. To the extent not included above, any and all instances where the account was rate limited and or action was taken by Twitter due to exceeding the rate limitation. Now we get into the meat of it. The subpoena identifies approximately 200 Twitter accounts to which the subpoena applies. So first in Fairfax, she's going after Adam Waldman and just his tweets that he's the agent of Johnny. Now all of a sudden, there's 200 Twitter accounts she's going after in California. Twitter Incorporated has not raised any objection to the subpoena. Only Mr. Depp has objected. It is imperative to note that the subpoena does not seek any personal information or private information from any individual users. They wanted all our IP addresses. The subpoena does not seek to ascertain the individual identity of the users, nor does it seek any identifying information from any individual users. The subpoena would not result in the unmasking of any individual Twitter's users. Well, Twitter has something to say about that. The purpose of the subpoena is that it is in the initial and least intrusive step in an effort to discover relevant information relating to the allegations in the counterclaim, specifically whether the identified Twitter accounts originated from the same or similar IP addresses as part of a concerted effort of the part of Mr. Depp and or agents on his behalf to harass and damage Ms. Heard. The inquiry is specifically tailored to approximately 200 user accounts who appear to have generated coordinated messages, specifically in order to ascertain how many counts and messages originated by the same or similar IP addresses. Only if the answer to the initial inquiry reveals such similarities or patterns, only then would any follow-up discovery issue. These requests are specifically tailored to seek discoverable information relating to Ms. Heard's third counterclaim, violation of the Virginia Crimes Act. Pursuant to the counterclaim, Ms. alleges in the relevant part that harassment by computer, which occurs when a person with intent to coerce, intimidate, or harass uses a computer to communicate obscene, vulgar, profane, lewd, lascivious, or indecent language, or makes any suggestion or proposal of an obscene act, or threaten any illegal or immoral act. As part of an ongoing smear campaign, Mr. Depp and or his agents acting on his behalf have directed both authentic and inauthentic social media accounts and or non-human controlled bots to target Ms. Heard's Twitter account and attempt to interfere with her contracts and or business expectancies. In particular, many of these accounts both smear and harass Ms. Heard while simultaneously promoting and praising Mr. Depp's agent and attorney, Adam Waldman. The talking points in these accounts are strikingly similar, but use slightly different text and content to evade Twitter's anti-spam and platform manipulation guideline. You mean we speak our own mind? We're not one person. to avoid Twitter's anti-spam and plan manipulation guideline, which bars harassing, abusive, and intimidating behavior except when viewed in the context of a larger conversation. A herd mentality helps mask predatory behavior. This is from her counterclaim. There are a number of newly created foreign language accounts specifically or predominantly designed to damage Ms. Heard. Many of these accounts have Cyrillic signatures reflecting Russian origin. Mr. Waldman, Mr. Depp's agent and attorney, is publicly associated with Russian individuals with the capability to organize such attacks. Oh, reaching. 2 accounts, iFodNet and MyGrindelwald, are responsible for approximately 50% of the targeted attacks on Ms. Heard. The MyGrindelwald account uses its platform to amplify anti-Heard hashtags and false information being disseminated about Ms. Heard. Now, remember in the trial, they even said justice for Johnny Depp was an anti-Amber Heard hashtag. So let's just keep this, close to what we already know from the trial. It has also amplified the change.org petitions described above, repeating calls from Ms. Heard to lose contract or business expectancies. And as evidence of its origin, it routinely tweets the statements of Mr. Depp's agent and attorney, Mr. Waldman, on a near daily basis, and often praises the otherwise unknown attorney, even goes so far as to say, "I love you, Waldman." A little jealousy there. In total, there were at least dozens, if not hundreds, of inauthentic accounts that impugn Ms. Heard while praising Mr. Waldman. Remember, they hired Boozy to suss this out, and he found 13 accounts. That's what was in the news article. This messaging further evidences the origin of Mr. Depp's unlawful campaign and demonstrates that these inauthentic accounts are actively coordinating content to manipulate the Twitter platform and avoid detection. In 2016, Mr. Depp texted his friend Christian Carino. So now she's going into this computer harassment because it was a text. So that's what she's trying now to go against him legally, because he said terrible things through a text, which I don't think I need to read. We know this one by heart. The parties, because this was about Twitter, this case, the parties have substantially and repeatedly met and conferred on numerous occasions in an effort to resolve the contentions regarding the alleged impropriety of the subpoena and have been unable to reach an agreement. Twitter has not produced any responsive documents to date since issuance of the subpoena in September. Well, of course not. The requested materials pursuant to the subpoena are relevant to the issues in the pending litigation. Ms. Heard simply wants to examine all relevant documents, 200 of us, by the way, necessary for her defense and affirmative counterclaims and to avoid prejudice. Ms. Heard specifically requests this court's assistance. So the subpoena was issued in September. This is now October 2020. So we're still several years before the actual case. Twitter, not so happy, issued a letter. And this is to Amber Heard's attorney in California. Cogger was her attorney in California. We represent non-party Twitter. And our receipt in receipt of your subpoena dated September 11th, 2020. And this is dated November. For the reasons stated below and for those discussed during our phone call, Twitter objects to your subpoena. Please contact me to meet and confer if you would disagree with Twitter's objections. First, Twitter objects to the definitions of communication and document as overbroad and calling for information covered by the attorney-client and work product privileges. Second, Twitter objects to the subpoena to the extent it seeks information that Twitter is legally or contractually prohibited from disclosing, including information that would require Twitter to breach a confidential contract, protective order, settlement, or other duty to a third party in maintaining privacy and or confidentiality. Third, Twitter objects to the subpoena to the extent it improperly purports to require the disclosure of documents containing privacy, proprietary or confidential information, trade secrets, or information implicating third parties' privacy rights. That's us. They cite a case. Requests are unduly intrusive and burdensome where they require confidential information and appear to be broad fishing expedition for irrelevant information. Fourth, Twitter objects to the extent your subpoena seeks information that it does not retain in a producible format. Fifth, Twitter objects that your subpoena is overbroad. I got something blocking me here. overbroad. All discovery requests must be relevant to the claim or defense of the subject matter or the underlying action. Going more. Page 2, request all correspondence records and documents are too broad. It is unclear why you require broad swaths of information about over 200 accounts, including several requests seeking any and all information without scope or focus. Indeed, the sheer number of accounts at issue suggests the subpoena is not narrowly tailored to seek only relevant information. Additionally, the subpoena's instructions indicate only that the time period is for the events at issue in the complaint. However, the complaint and counterclaims cover events dating back to 2016, and the subpoena contains no end date for a time period. It is unclear if the subpoena, in fact, seeks over 4 years' worth of data, or if so, whether such data range is narrowly tailored to the claims and defenses in your litigation. 6, Twitter objects to the subpoena is unduly burdensome. Courts recognize that non-party discovery must occur only if the information sought is not available through discovery from the parties in the litigations themselves. Moving forward, if you seek information about Twitter accounts that you believe the plaintiff in your litigation owns or controls, you should seek discovery from him before burdening non-party Twitter. Further, even if this information is not available to plaintiff, Twitter objects that locating and producing the multiple categories of data you seek for over 200 accounts would impose an undue burden. 7th, Twitter objects to the extent that your subpoena seeks electronically stored information that is not reasonably accessible because of the undue burden or expense or other than in the forms that such information is ordinarily maintained. If Twitter agrees to produce responsive information in the future, it does not agree now. Twitter will produce reasonable, available, electronically stored basic subscriber information in the forms, and it is ordinarily maintained. 8th, Twitter objects that you have provided no documentation demonstrating that the court considered and imposed the First Amendment safeguards required before a litigant may be permitted to unmask the identity of an anonymous speaker. Before a service provider may be compelled to unmask an anonymous speaker, a reasonable attempt to notify the user of the request and the lawsuit must be made. Therefore, thereby providing the user an opportunity to assert his or her First Amendment right to speak anonymously through an application for a protective order or a motion to quash. The plaintiff must make a prima facie showing all of the elements asserted cause of action. So they're saying, hey, go contact these counts yourself, first off. Moreover, the party seeking discovery must demonstrate a compelling need for the anonymous speaker's identity. Obvious invasions of interest fundamental to personal autonomy must be supported by compelling interest. Also, denying motion to enforce subpoena against Twitter where movement failed to overcome users' First Amendment right to anonymous speech. 9th, Twitter objects to the federally stored communication does not permit private parties to compel production of the content of an account holder's electronic communications from service providers such as Facebook by service of a subpoena or court order. There is no exception under the SCA for civil discovery demands, and courts have therefore uniformly held that SCA does not permit civil litigants to compel service providers such as Twitter to produce the content of electronic communications in response to civil discovery demands. Twitter's holding strong for us. To the extent that you seek the contents of user communications, i.e. deleted materials, the SCA prohibits Twitter from complying with such requests. Please feel free to contact me at the telephone number, etc. So they're still meeting conferring. So back in Fairfax now, we have the counterclaim. Johnny filed a demurrer against the counterclaim. This is January 4th. Obviously, there was a lot of elements in there, but let's just stick to the part about the Virginia computers law, because that's what we're just talking about with Twitter. So let me jump to that. I needed to show you the date on this. Slap. Per se overruled. I think it's toward the bottom. Here. Under the Virginia Computer Crimes Act, a claimant must prove that 1, the person used a computer or computer network, 2, communicate obscene, vulgar, profane, lewd, lascivious, and or indecent language, or make a suggestion on proposal of an obscene nature or threaten any illegal or moral act. None of Ms. Heard's allegations satisfy all three prongs of the VCCA. First, Ms. Heard has alleged that Mr. Depp used a computer or computer network in 4 instances when he initiated, coordinated, oversaw, and or supported and amplified 2 Change.org petitions. When he created, controlled, and or manipulated social media accounts, when he texted Mr. Bettany in 2013, and when he texted Mr. Carino in 2016. This court now examines each of these instances to determine whether they meet the other 2 VCCA prongs. The allegation that Mr. Depp has initiated, coordinated, overseen, and or supported and amplified 2 Change.org petitions, one to remove Ms. Heard as an actress in the Aquaman movie franchise and one to remove her as a spokesperson for L'Oreal, fails under the second prong of the VCCA. Nothing in that allegation implies facts showing that the Change.org petitions included obscene language, threatened illegal or immoral acts, or suggest or propose obscene acts. Likewise, the allegation that Mr. Depp created, coordinated, controlled, and or manipulated social media accounts created specifically for the purpose of targeting Ms. Heard also fails under the second prong. The pleading fails to demonstrate that the social media accounts communicated obscene language, suggested obscene acts, or threatened illegal or immoral acts because neither of those allegations meets the second element of the VCCA. They cannot move forward in this litigation. Remaining 2 allegations, and these are the texts, computer also usage fail into the third prong. Ms. Heard was not alleged that they were made with the intent to coerce, intimidate, or harass. Rather, it appears that Mr. Depp texted those statements privately to 2 of his friends. Ms. Heard has not alleged that Mr. Depp intended for her to see them. Accordingly, this court sustains the demurrer to count 3. So it's now out. It's done. It's finished. No more Twitter campaign as far as her counterclaim. It has been sustained. Johnny won his demurrer on this section. She's out. But they're not going to give up. And this is what I wanted to show you here. I don't think you can see this, but this is 168 pages. I've bought these documents. They're very expensive. I get very frustrated when I'm buying documents that include things that were free from Fairfax, for example, but I have no way of knowing that. There's a lot of information in here that I know you'll all be interested in. And I think that the accounts will be listed. So again, this is now January 27, 2021. And this is the latest status report. Now, again, Fairfax has already said you're out. We're not going to, you can't pursue this avenue, but she's not stopping. On August 10th, 2020, Ms. Heard caused to be served Twitter Incorporated with a subpoena for production of business records in an action pending outside California. The first subpoena required Twitter to produce the requested records by September 8, 2020. On September 14th, Ms. Heard caused to be served on Twitter a second subpoena. See, that's the one we didn't see that we're hearing about in here. Of business records and action pending outside of California. The second subpoena collectively with the first subpoenas. The second subpoena required Twitter to produce the requested records by October 1st of 2020. The first subpoena sought all posts made and messages sent or received by Twitter account Adam Waldman. We saw that. That's the one we can see publicly in Fairfax. The second subpoena, which we didn't know existed until I happened upon these documents, the second subpoena sought various documents in connection with the screen names listed in the second subpoena, which had been identified as being involved in an online false and defamatory smear campaign against her. Seeking 1, connected IP addresses, 2, if the account was ever suspended, and if so, the reason for each suspension, 3, source information for tweeted messages, meaning whether the tweet originated from a computer or a phone, 4, a count of the number of messages. She goes 4 again. I think they mean fine. The reasons for the messages deleted from the terms of service violation. And 5, any instances where the account was rate limited or action taken by Twitter due to rate limitation being exceeded. This is interested. Is this rate limited we would have known about? Like you followed too many people on one day, you tweeted too much, or is this shadow banning that's happening behind the scenes? The purpose of the second subpoena is to ascertain whether a concerted effort to defame Ms. Heard was perpetrated by the agent of Mr. Depp, Mr. Waldman. The stated intent of the second subpoena is to avoid unmasking the individual identities of any individual users of Twitter. To avoid. The counterclaims of petitioner specifically allege that defamatory statements by Mr. Waldman on behalf of his client, Mr. Depp, caused damage to petitioner, and that the computer-based attacks on Ms. Heard are intimately connected with the defamatory statements. Now remember, Fairfax has already thrown this out with Johnny Depp's demur. They've already sustained it. This is not part of her counterclaim anymore. Those statements and conduct are intermingled with the malicious conduct of Mr. Depp and his agents and directly relate to the damages suffered by Ms. Heard. Mr. Waldman's conduct is at the front and center of the allegations in this litigation. Mr. Waldman is no longer counsel of record for respondent in this action, as his pro hac vice status was revoked by Virginia trial court, and Mr. Waldman has not entered an appearance in the California court proceedings for this matter. A copy of the Virginia court's order vacating his pro hac vice status is attached. So now they're just trying to make him look like a bad guy to the judge. Matters at issue. The first subpoena seeks discoverable information. The first subpoena seeks two categories of documents, posts, and messages. Ms. Heard has agreed to withdraw the request for messages sent or received by Twitter account Adam Waldman as requested by counsel for Twitter. However, Ms. Heard still seeks all posts made by this account. It feels like the same thing. Ms. Heard still seeks all posts made by this account, which are in the public domain and are discoverable. As of the time the statement was filed, January 26, 2021, no documents have been produced by Twitter in response to the first subpoena. Did I read that wrong? Ms. Heard has agreed to withdraw the request for messages sent or received by Twitter account Adam Waldman. However, she still seeks all posts made by this account. Oh, I guess messages? Are they talking about direct messages maybe? Private chats? The items are requested from Twitter to establish the existence of Mr. Waldman's conduct from a third-party source. The second subpoena seeks discoverable information. As to the second subpoena, counsel for Twitter provided written objections by letter dated November 10th. Counsel for Ms. Heard responded to such objections by letter December 15th. Copies are attached below. Hopefully they'll be there. Twitter has raised a number of unsustainable objections as set out in counsel for Ms. Heard's December 15th letter. The second subpoena is specifically tailored to avoid the disclosure of personal user information and content and does not request the unmasking of any Twitter users. The second subpoena does not seek information that would disclose the private content of any direct messages. Direct messages, that's the private chat, the DMs. The second subpoena does not seek the production of any confidential or proprietary information. The second subpoena seeks information that is not available through any other party to the litigation. The second subpoena is not intended to seek the production of documents that are protected by the attorney-client or work product privileges. There is no right to privacy with respect to an IP address because an IP address alone does not provide any personal information regarding the Twitter user. Finally, the subpoena does not seek any content of user communications, nor does the subpoena request the content of direct messages. And thus the Federal Stored Communications Act cited by Twitter is not applicable to Ms. Heard's discovery request. Counsel for Twitter has raised an objection on the grounds of relevance. However, Ms. Heard's counterclaim, which has already been ruled against, we have to keep remembering that, alleged inter alia that Mr. Depp has authorized and conspired with his attorney, Adam Waldman, acting on Depp's behalf to attempt to destroy and defame Ms. Heard in the press, accusing her of being a serial liar who created the abuse she endured from Depp, which is not true. Jury disagrees. Jury agrees it was a hoax. And further, that Mr. Waldman made a number of false and defamatory tweets via his Twitter account, Adam @Waldman, with the malicious intent to defame and harm Ms. Heard. We'll see those tweets that she's so upset about. Accordingly, the statements made via the Twitter account, Adam Waldman, are highly probative as to Mr. Waldman's intent and levels of malice against Ms. Heard. Remember, only the statements from the Daily Mail came in. Ms. Heard's counterclaim further alleges that Mr. Depp and his agents acting on his behalf have directed both authentic and inauthentic social media accounts and or non-human controlled bots to target Ms. Heard's Twitter account. Many of these accounts both smear and harass Ms. Heard while simultaneously promoting and praising Mr. Depp's agent and attorney, Adam Waldman. We did have a bit of a love fest going on for Adam. You have to admit, there was a bit of a love fest. The discovery sought from Twitter is directly relevant to such allegations and to her claim for defamation. It goes directly to the determination of whether the actions of Mr. Depp and his agents were willful, malicious, and wanton, and demonstrate a reckless and conscious disregard for the truth or falsity of his statements, of Ms. Heard's right to be free from statements that defame her and wrongly impair her right to work in her profession, and further constituted actual malice, as alleged in her counterclaim. Additionally, the online attacks on Ms. Heard surrounding the following the defamation are evidence supporting Ms. Heard's damages. The statement are reflective of and are as a result of Mr. Depp's defamation of Ms. Heard and have themselves caused further harm to Ms. Heard. Through such conduct, Mr. Depp, either directly or through his agents, including Waldman, is attempting and threatening to defame Ms. Heard and to interfere with Ms. Heard's reputation, career, and livelihood, and cause financial damages, and he and his agents are doing so through this online smear campaign that he's orchestrated and organized. The discovery sought from Twitter is intended to prove the truth of these allegations, as well as evidence Ms. Heard's damages. As such, it is calculated to lead to the discovery of relevant, admissible evidence. Moreover, as noted by this court in its court order dated October 29, 2020, the legal standards for admissibility of evidence at trial is quite different than the legal standards applicable for the purpose of discovery. To be relevant for the purposes of discovery, the information sought must be relevant to the subject matter of the pending action, to the determination of the motion in this action. Well, it's not pending because it got thrown out. I don't think Twitter knew that. Remember, Depp is not involved in this now. This is Amber Heard versus Twitter in the California court. The information sought must be relevant to the subject matter of the pending action or the determination of motion in the action. Such a standard is broader than relevancy for purposes of determining admissibility at evidence at trial. For discovery purposes, information is relevant if it might reasonably lead to admissible evidence or might reasonably assist a party in evaluating the case, preparing for trial, or facilitating a statement. Any party may obtain discovery regarding any matter not privileged that is relevant to the subject matter involved in the pending action or to the determination of any motion made in the action if the matter either is itself admissible in evidence or appears reasonably calculated to lead to the discovery of admissible evidence. So says that case. The rules are applied liberally in favor of permitting discovery. The information which Ms. Heard seeks from Twitter is intended to prove the truth as to whether respondent has defamed Ms. Heard through the use of authentic and inauthentic Twitter accounts and acted maliciously in doing so. Of specific import, which cannot be stressed enough, the second subpoena does not seek to identify specific individuals' identities or the content of any tweets. Yeah, Twitter has something to say about that. The second subpoena seeks to discover whether there is a pattern amongst the improper conduct attributable to Mr. Depp. As of the time the statement was filed on January 27, 2021, no documents have been produced by Twitter in response to the second subpoena. Good for you, Twitter. Counsel Ms. Heard met and conferred with Twitter's counsel via email in a reasonable and good faith attempt to resolve the outstanding issues with the subpoenas without court intervention. It is understood that Twitter is reluctant to produce the materials that would impede the user's First Amendment rights and to avoid identification of users via unmasking. However, the subpoenas at issue here are not directed to ascertain such information. Remember, they're looking for IP addresses. Exhibit A. This is now the second subpoena. Produce books, documents, see attached. Let's see what they say. Definitions. All right, so this is the first subpoena. See, again, I paid for this, something we got, what, 21 pages out of this for free already? Watch your eyes, guys, because it's going to be in here a second time. There it is the second time. This is why I hate having to buy documents up there. Okay, this must be the second one coming up. This is the one that was filed in Fairfax, but it was never made public. Instructions. Here's what we're looking for. In response to the subpoena, you are required to produce the following for each of the screen names listed on the following pages. Note that we are not requesting unmasking of these. So we already saw this before. IP addresses they want, to the extent not included above, any and all IP addresses from which the accounts logged in. IP addresses where they're registered, to the extent not included above any and all IP addresses from which the account tweeted messages. So they want to track us. They want to know where we're going. If the account was ever suspended and the reason for the suspension, a list of any and all source information for tweeted messages from the account, Twitter for Android, Twitter for iPhone, or the computer. A count of the number of messages tweeted from this account that were removed due to TOS violations. For each message that was deleted for the TOS violation, the reason. To the extent not included above, any and all instances where the account was rate limited or any action was taken by Twitter due to exceeding of a rate limitation. I'm going to go slowly. I'm not going to read out every name, but you can pause it to see if your name is on here. These are the 200 Twitter accounts they're looking for. Now, remember when this was back in 2021? Names could have been, people could have left. Maybe you changed your name. Maybe you were suspended and came back again. But here's a list of names. I just recommend you pause if you want to look. Going to the next section. These are all the Twitter names. There's 200 accounts. Here's the next section. Going on to the next section. Going further. There's Mike Grindelwald that they mentioned. I know iPod's on here. Going on to the next section. There I am. Going on to the next question. One, I Cool Whip. Going on to the next section and the end. So these are all the accounts they were looking for IP addresses on from this. It's going to be repeated, so hold on while I get back down to see if we have any other attachments. Watch your eyes. I think they were complaining about some of Adam's tweets. Let's see if they connected them. So this is where Adam's pro hack Vici was revoked. There's no reason given. This is the letter I already just read to you from Twitter. So it was a lot of pages here, but we got a lot of good information. This is December 15, 2020. So this is their answer. It looks like it's their answer to, yes, this is Amber's attorney. Now she's writing back to Twitter. This letter was served to respond your correspondence of November 10th, in which your office asserted objections to the subpoena dated September 11, 2020. Issuance to non-party Twitter on behalf of defendant and counterclaimant Amber Laura Heard. As you know from our communications, this office represents Ms. Heard in the above referenced matters. Respectfully, we disagree with the objections included in your correspondence. At the outset, we want to stress that the subpoena is specifically intended to avoid the disclosure of personal user information and content, and specifically notes that the subpoena does not request the unmasking of any screen names. The following will serve to respond to that. The subpoena does not seek and is not intended to seek the production of documents that are protected by attorney-client or attorney-product privileges. Subpoena does, however, require that a privilege log be served with Twitter's responses and production to the extent that such is applicable. We do not request production of any materials which Twitter believes to be subject to either the attorney-client or work product privileges, as no content is sought by the subpoena. It's clear how much materials could be at issue. Again, they're looking for IP addresses. Subpoena does not seek information that would disclose the private content of any tweet or post. Rather, the subpoena seeks information identifying any terms of service that were violated, resulting in suspension of an account, not the content of any such tweet. Similarly, the subpoena seeks the total number of the messages tweeted from the accounts that were removed for TOS violations, not the content thereof, and so on. Such information does not disclose contractually prohibited, confidential, or private information. Twitter's third objection. Further, to response of this objection, the subpoena does not seek the production of any documents or confidential materials. Citing the case that they did in the letter, the court granted petitioner's motion to compel responses to the subpoena served on the respondent. That court held, for example, that there is no right to privacy with respect to an IP address because an IP address alone does not provide any personal identifying information. It may be used to obtain such information, but the IP address itself is not private. It may be used to obtain such information. Going on, the subpoena does not seek documents that would disclose proprietary information, trade secrets, or implicate third-party privacy. That's us. The subpoena requests identified in the objections numbers 4 through 8 are patently clear that they do not seek documents or private information, but rather identification of terms of service violated, the volume of messages removed, any rate violation. The requests do not seek substance of the messages. Response to Twitter's fourth objection. The objection appears misplaced. By way of cursory inquiry, Twitter's Help Center general guidelines and policies indicate that at the times a notice is added to an account or tweet to give the user context on the action taken by its systems or teams, which can be because the behavior violates the Twitter rules. Examples in recent media are equally plentiful. For example, on or about October 6, 2020, Twitter hid a message posted by the real Donald Trump behind a warning about spreading misleading and potentially harmful information. We ask that you clarify your position that Twitter does not retain information responsive to request number 4 to 8 in producible format. We believe this objection to lack of basis, the fifth objection, regarding relevance, Ms. Heard has filed a counterclaim against Mr. Depp alleging defamation and violation of the Virginia Computer Crimes Act. At the time of this letter, it wasn't ruled on until January, so this is November. Under the Virginia Crimes Act, it is unlawful to harass by computer, which occurs when any person with the intent to coerce, intimidate, or harass uses a computer to communicate obscene, vulgar, profane, lewd, lascivious, or indecent language, or make any suggestions or proposal of an obscene nature, or threats any illegal or immoral act. Ms. Heard's counterclaim attached for your review alleges in relevant part as follows. As an ongoing smear campaign, Mr. Depp and or his agents acting on his behalf have directed both authentic and inauthentic social media accounts in or non-human controlled bots to target Ms. Heard's Twitter account and attempt to interfere with her contracts in or business expectations. In particular, many of these accounts both smear and harass Ms. Heard while simultaneously promoting and praising Mr. Depp's agent and attorney. The talking points in these accounts are strikingly similar, but use slightly different text and content to evade Twitter's anti-spam and platform manipulation guideline. I'd love to know how bots could put out the same message, but slightly different. Obviously, the subpoena seeks information for relevant subject litigation. So they're referring that this is why we need it because it's part of her counterclaim. We do not disagree with the premise that as between parties to litigation and non-parties, the burden of discovery should be placed on the latter only if the former do not possess the materials sought to be discovered. The court, in this case, cited in your correspondence on behalf of Twitter, states that an exception to this may exist where a showing is made that the material obtained from the party is unreliable. That would be Depp or Waldman. It may be subject to impeachment by material in possession of the non-party. That's Twitter. The party from whom the court believed the discovery could be obtained without burdening a non-party to the litigation had previously been involved in litigation against a non-party regarding the same subject matter. Further, the categories of materials to be produced were described in a 12-page attachment to the subpoena that included almost 3 pages of definitions and 3 pages of instructions. Further, the requesting party did not even attempt to demonstrate why it could not obtain the needed materials from the party. The situation is clearly distinguishable here, as the information sought is not available through any other party to the litigation and can only be obtained by Twitter. Depp and Adam obviously have no clue what their imaginary bots are doing, apparently. Additionally, in the sphere of Twitter's practiced automation of searches, it is inconceivable that it would be unduly burdensome for Twitter to identify simply the number of messages tweeted from the accounts that were removed due to TOS violations. Ms. Heard invites Twitter to explain this burdensome process. Seventh objection, similar to the above, we invite Twitter to explain its unduly burdensome on this, to obtain the electronically stored information. As clarified above, this is the eighth objection, there is no right to privacy with respect to an IP address, because an IP address alone does not provide any personal identifying information. It may be used to obtain such information. So we're getting on a slippery slope here, but the IP address itself is not private. Therefore, the production of an IP address does not unmask the identity of the anonymous speaker as claimed in your correspondence. Again, we invite Twitter to explain its procedures for deletion of the information requested, given that Twitter routinely shuts a user down for a period of time if the user posts an excessive number of tweets or API queries too quickly. It cannot be understated that the subpoena does not seek any contact of user-stored communications, nor does the subpoena request the content of direct messages. Therefore, the Stored Communication Act is not applicable. Please contact us for further. Let's see what else they put in here. Okay. See, this is where I get a lot of pages, again, I pay for that I didn't need. I'm going to save your eyes on this one. This is her counterclaim, which is mucho long. And we have that for free from Fairfax. And I already touched on the relative part of it. So let's get off of the counterclaim and see if there's anything else on here. This is the article that she's included. She included the entire articles, by the way, which were not redacted. Again, I got that for free. I didn't need to pay for that. I find this one interesting. Let me just jump to this page, because the one that claim that survived here we show the actual LAPD report. This was the teletype from New York Police Department, because IO called in there, but it didn't get transferred until 10:09 to California. It was reported, yeah, teletype from New York PD. So the whole thing's not in here. And then we have this one at 9:22. It's when they got there. Anyway, moving on. These are all the articles that she attached to her counterclaim. Moving on, and they were all redacted. The entire articles were redacted except for just the one sentences. Many of these articles were time barred. Oh, pages upon pages of this I had to pay for, of useless information. Just making sure if there's anything at the bottom. I thought they were going to highlight some of Adam's tweets. No, they didn't. They did not. But back to California. Now, this is dated January 27th. This is most definitely after the counterclaim was sustained. You know, Johnny's demurrer was sustained. So we're back to another informal discovery conference. We know that Amber Heard issues subpoena. The accounts are anonymous. The governing law. We know all this. We don't have to. There's 200 of them. Proposed solutions. Twitter respectfully proposes that the court direct defendant to file a motion. Wait, did I miss number 2? Oh, wait a minute. This is filed by Twitter. This is filed by Twitter. So this is new. Defendant Amber Laura Heard issued a subpoena to non-party Twitter in connection with the litigation against plaintiff John C. Depp in the Circuit Court of Fairfax County, Virginia. The subpoena seeks, in relevant part, IP address information for over 200 Twitter accounts, which defendant alleges are bot accounts. The published smears and misleading statements about her and were maliciously operated by or at the direction of plaintiff. The accounts are anonymous. Their usernames do not reveal the identities of the individuals who operate them. At issue are defendants' requests for IP address information for each of the accounts. IP address information can be used to unmask anonymous speakers. Equipped with this data, defendant can subpoena the relevant internet service provider for the identity of the individual or entity related to each IP address. Twitter has not received and is not aware of any evidence in support of defendant's allegations about the account's speech. For example, defendant has not identified any specific tweets from any accounts that she alleges are defamatory. Therefore, Twitter does not believe the subpoena has satisfied the First Amendment safeguards applicable to anonymous speech, and Twitter's position is that defendant must seek a determination from the court regarding whether over 200 anonymous speakers may be unmasked. I'm going to drop down to this. Twitter received defendant's statement this afternoon before this conference. Twitter does not have sufficient time to fully respond to defendant's contentions and reserves the right to do so at a later time. But at a high level, Twitter disagrees with defendant's presentations of the issues. In particular, Twitter does not understand this conference to encompass issues relating to defendant's subpoena concerning the @Adam Waldman account. However, as defendant notes, she agreed to withdraw her request for messages sent or received by this account. That would be the direct messages. To the extent defendant still seeks all posts made by this account, which are in the public domain and are discoverable. They are publicly available and therefore equally accessible to her. Go read Adam's tweets yourself. Accordingly, there's no need for Twitter or non-party to search and produce these. Actually, that would be the same for all of those 200 accounts. Go do your work and go look for them on your own, which, as I recall, she had her daughter do, and we caught them out on that. To unmask an anonymous online speaker, the First Amendment to the U.S. Constitution and the California Constitution requires litigant to establish a prima facie cause of action and to attempt to notify the speaker. Moreover, the California constitutional right of privacy requires a showing that there is a compelling need for the discovery that outweighs the privacy rights of the speaker. That's us. No court has applied the standard here. Twitter seeks to ensure that the applicable standard is satisfied before it produces information that could be used to unmask over 200 anonymous accounts. In particular, it is unclear to Twitter whether defendant has established a prima facie case of action given the absence of evidence in her counterclaims and exhibits as to any defamatory speech from these counts. Given these issues, Twitter's position is that a court must undertake the applicable balancing test before Twitter can produce the requested data. Proposed solution. Twitter respectfully proposes that the court direct defendant to file a motion to compel, requesting that the court undertake the relevant First Amendment analysis and enter an order reflecting the court's determination. Twitter is not prepared to produce absent such an order. If the court concludes the subpoena satisfies the First Amendment, Twitter will provide notice to the users and provide them with 14 days to file a motion to quash the subpoena. After the 14-day period expires, Twitter will produce responsive data for all accounts. So basically, they're saying, go get it yourself, put up or shut up. So we finally have a ruling from the judge on the informal discovery. The court conducted an informal discovery conference regarding the Twitter Incorporated subpoena and the subpoena issued to non-parties. That was a whole nother party. The parties had to further meet and confer. So they're throwing it back on. The judge is not issuing a motion to compel against First Amendment. Supplemental status report. This is filed by Amber Heard. Pursuant to the court's request, they submit this supplemental information discovery conference status report. The court requested the petitioner provide samples of defamatory statements by Twitter users in the second subpoena. Some sample tweets from usernames identified in the second subpoena are as follows: at Mary C. Joyce 2. Even after it was proven that he is a victim, they're still publishing in support of his abuser, Amber Heard. This goes deeper than just covering up for an abuser. Who's a nobody? This is defamatory. Depp Girl 2. This is a retweet. What's up here? That was a tweet. Now this is a retweet. This is the face of a female abuser, false accuser. Platoon 1979. Retweet. Friendly reminder that Amber Heard abused Johnny Depp, then lied and said he abused her so she could advance her own career while destroying his. Remember, the audio tapes are out by now. We've all heard them. And then these are retweets. I'm not sure who the original author of these are, because these are retweets. This person just retweeted it, which we already know without adding context. It's not defamatory. Johnny Depp is a victim of a stalker, a violent narcissistic sociopath who tracked him down, conned him, love-bombed him, gaslit him into marriage, then started her systematic dismantling of his core sense of self, violently abused him, then blackmailed him, then smear. Retweet. I'm so proud of all these Depp heads and hashtag Justice for Johnny Depp supporters standing up to fight back against Amber Heard and her lies. Amber Heard is a liar, not a bot. Stand proud. The truth always comes out. Amber Heard abused Johnny Depp and attempted to frame him. These are all retweets to fame him. Amber Heard has lied. So she was not named. Is that what the sick means? Has lied to multiple governments across the world. Amber Heard sliced off Johnny Depp's finger, caused him to contract MRSA 3 times, burned his face with a cigarette, shat on his bed, spat on him, withheld his medications, punched him. He lost his job and she didn't. Justice for Johnny Depp, Amber Heard. Remember, they were talking about these hashtags. This is a pro Johnny Depp. These are examples of the context of these Twitter users for which the IP addresses, not individual user informations, are sought. As noted in the pleadings, many of these accounts have Cyrillic signatures reflecting Russian origin. These samples are retweets of other users' content. Exactly. A retweet without additional information or context is not defamatory. We know that from Amber's tweet of the article. It was because she added in additional information. These samples are retweets of other user content. Well, why didn't they use the original content? These accounts republish the content of other users at rates and consistencies that belie authentic human control. All the accounts identified in Subpoena, a random search of those accounts showed that multiple accounts identified in Subpoena have been suspended, while multiple accounts do not exist any longer. Well, people come and go. And yeah, you dogpile and report us. This tweet was viewed on Friday, January 29th, and this user was a specific user discussed during the IDC. As January 20, as of February 20, has been suspended by Twitter. Mary C. Joyce. Even after it's been proven that he's a victim. So her account has now been suspended. While it is possible or even likely that some of these users are not bots, the purpose of the subpoena is to identify whether a pattern of actionable conduct exists, whether the accounts are generated from the same or remarkably similar IP addresses. Finally, Twitter has requested in its own IDC status report that the court direct petitioner to file a motion to compel so the court can undertake the relevant First Amendment analysis and enter an order reflecting the court's determination. At the risk of repeating the scope of the subpoena ad nauseum, there is no First Amendment analysis necessary here. Should the matter not be capable of resolution at this IDC, there are no First Amendment concerns at issue here. No content or user information is being sought via the subpoena. The second subpoena does not seek to learn identities of users or to silence content, as neither individual user information or any specific content are sought by the second subpoena. Well, Twitter already said you could go to the AT&T or Spectrum or Comcast or whoever your IP address is and subpoena them for the information of the owners. Twitter has the final word. This is now February 8th. Defendant Amber Heard issued a subpoena to non-party Twitter in connection with litigation against Depp. We know that. Seeking, in part, IP address information for over 200 Twitter accounts, which defendant alleges are bot accounts. The accounts that supposedly publish smears and misleading statements about her were maliciously operated by or at the direction of plaintiff. During a January 28th informal discovery conference, defendant's counsel stated that he would narrow the subpoena to seek IP addresses information only for the 2 Twitter accounts the counsel claimed were the worst offenders. The court agreed, but required defendants to submit evidence of defamatory statements posted on Twitter by those 2 accounts. The court also disagreed with defendants' representation that subpoena did not seek identifying information because IP addresses can be used. So the court disagreed with them, not just Twitter. The court says IP addresses can be used to unmask anonymous speakers. Defendant's supplemental status report does not appear to identify sufficient evidence of defamation. And from Twitter's perspective, if the defendant intends to pursue the subpoena further, she must obtain a court order confirming that her request satisfies the First Amendment. Governing law. To unmask an anonymous online speaker, the First Amendment to the U.S. Constitution and the California Constitution required litigant to establish a prima facie cause of action and to attempt to notify the speaker. So they had to let us know first. Moreover, the California constitutional right of privacy requires a showing that there is a compelling need for the discovery that outweighs the privacy rights of the speaker, according to these other. Now, here we go. This is what the court ruled. Equipped with IP addresses, defendant can subpoena the relevant internet service provider for the identity of the individual or entity related to the IP address. Discussion. Let me have a little sip here. Twitter's final word. It is unclear to Twitter whether defendant's new evidence establishes a prima facie cause of action. Several of the quoted statements appear to be neutral statements or opinion. They include language such as, "I'm so proud of Depp fans," or refer to defendant, a movie star, as a nobody. Defendant Supplemental Information Discovery Conference Status Report 1-2. Even tweets that appear ambiguous may be statements of opinion, given the nature of the underlying litigation. The fact that allegations in the litigation are newsworthy and hotly debated by fans of the parties, as plaintiffs and defendants counsel attested to in previous IDC, and the parties' celebrity status. Moreover, almost all of the identified statements are retweets, dissemination of another account's tweet, and the act of retweeting could be expressing an opinion about the retweeted statements. Note this. Good for you, Twitter. Additionally, some or all of the statements could be true. Accordingly, Twitter is concerned that defendant's evidence is anonymous speech that has protected opinion about two public figures. I love that. Additionally, some of these statements could be true. Given these issues, Twitter's position is that a court must undertake the applicable balancing test before Twitter can produce the requested data. As noted in Twitter's previous statement and discussed at length during their IDC, the IP address information defendant seeks can be used to unmask anonymous speakers. Defendants' representations to the contrary are misleading and ignore the court's conclusion in January 28th that the request for IP addresses do seek identifying information. Additional issues with defendant's supplemental statement. Twitter is also concerned about two additional aspects of defendant's supplemental statement. I don't have all the documents. I tried to get them, did the best I could, because not all of them get uploaded. First, the statement still appears to raise arguments related to defendant's harassment claims, even though the Circuit Court of Fairfax denied defendant's harassment claim in January. Boom! Somebody finally told Twitter. And this Twitter is now telling this judge, like, hey, this was already denied. She's been shoving this down our throats, and we know it's been denied. And this isn't until much later. Denied defendant's harassment claim in January, as the parties discussed at the January 28th. These accounts republish the content of other users at rates and consistencies that belie authentic human control. Whether or not these accounts are bots relates to defendant's claims of coordinated harassment, it has no bearing on the defamation claim that defendants cited as justification for continuing to pursue the subpoena. Given the parties' discussion at the January 28th IDC that the subpoena is moot as a defendant's harassment claim, it is unclear to Twitter why defendant has raised this issue again in her supplemental statement. The IDC that we saw a write-up before the informal discovery conference, but they're referencing more like what actually was said, the transcripts, and I wish we could get that. But the judge was having none of it, it appears. Second, defendant's statement appears to ignore counsel's January 28th narrowing of the subpoena to the two worst offenders, which was poor Mike Grindelwald and IFOD. The statement cites tweets from several different accounts, not just two, and discusses characteristics of many accounts, and didn't provide any tweets from the two we assume are supposed to be Mike Grindelwald and IFOD, right? These representations and arguments overlook defendant's counsel commitment to narrowing the subpoena during the January 28th IDC. Proposed solution. Twitter respectfully proposes that if defendant intends to pursue the subpoena further, she must, 1, limit her request to 2 accounts, consistent with her counsel's agreement to do so. at the January 28th IDC, and 2, seek a determination from the court regarding whether those accounts may be unmasked in light of the fact that only her defamation claim, not harassment claim, remains. In addition, Twitter seeks confirmation that the Adam Waldman subpoena has been withdrawn. That was it. That was the last we heard of it. Yep, last we heard of it. They were having nothing. The judge saw right through it. They were not going to unveil us. They were not going to unmask us. They were not going to hand over our IP addresses. Then they finally found out that it was actually dispensed with from the demurrer being sustained. I would have loved to have seen a transcript of that hearing. I could just imagine the judge was pissed. So that she could no longer claim harassment. She can only claim defamation. They didn't even provide any defamatory statements or tweets. And the best one was, and Twitter says, and hey, they might be true. When I first posted these things, what came out of this was the hashtag, "We just don't like you, Amber Heard." Based on, wasn't harassment. It's not defamatory. We just don't like you. So that's what I have today. This is, again, this is the road to Fairfax. This is the pre-trial battlefield. This is what was going on in California with Twitter. And they put their foot down and they said, no, we're not giving you any of this information. And the judge agreed, and it did not come into trial. And neither did any of much of Adam's. Oh, they didn't provide any of Adam's Twitter either. They pulled that because they can go on Twitter and find it for themselves. So that's what I have. I hope you're finding this interesting, especially since this one was about so many of us. And it was nice to know Twitter had our back. So you guys have a great, this is the holidays. This is Christmas. I'm not sure. I'm going to be taking some time off. But yeah, I hope you enjoy this, and everybody have a great holiday. Thanks. Bye-bye.